You tell me when.
Go ahead.
All right. The House Committee on Labor will come to order. Will the clerk please take attendance?
Chair Hadsma.
Here.
Representatives Menser. Olazar. O'Neill. Andrews. Here. Churches.
Present.
Magella. Here. Wozniak. Here. Mueller. Here. Here. Mr. Chair, you have the floor.
Thank you. May I have a motion to adopt minutes from November 2, 2023? I'm proposing an additional committee rule regarding testimony at committee to clarify our procedures at committee. You each have a copy of the proposed rule at your seat. Representative Menser moves to adopt the committee rule. Will the clerk please call the roll?
On the motion to adopt the rule, Chair Hadsma.
Yes.
Representatives Menser.
Yes.
Olazar.
Yes.
O'Neill.
Yes.
Andrews.
Yes.
Churches.
Yes.
Magella.
Yes.
Wozniak.
Yes.
Mueller.
Yes.
Kuntz.
Yes.
Mr. Chair, 10 yeas, 0 nays, 0 passed. The rule is adopted.
Thank you. Next item up is a presentation on the new federal rule on independent contractors and how that will impact Michigan workers and businesses. I invite up Sean Egan from Michigan's Labor and Economic Opportunity Agency. Good morning.
Good morning, Mr. Chairman, committee members. Pleasure to be with you today. I was invited to come over and talk a little bit about a rule that has been issued and finalized by the U.S. Department of Labor, Wage and Hour Division, regarding the classification of employees. As you all know, as the chairman just said, I'm the Deputy Director for Labor in Michigan's Department of Labor, so I primarily oversee MIOSHA, Workers' Comp, the Bureau of Employment Relations, and our Wage and Hour Division. And with me today is State Assistant Administrator Rando Harrison, who works with me in the Department of Labor, but was also a wage and hour investigator for 16 years prior to that role, so he has extensive experience in this area. So just a quick update on this. As you know, this is a federal rule, so we don't necessarily get into all the details of how they analyze this, but it's certainly something that's going to impact Michigan employers and workers, so we want to make sure that everybody's aware of it. And we also will be working with our counterparts at the USDOL to put together some webinars and other tools that employers can engage with to understand the purpose of this rule, what's included in the rule, and otherwise. So importantly today and this morning, the new rule becomes effective on March 11th. So just a couple of weeks from now, the DOL is going to start changing how they evaluate the employment relationship. And important for Michigan employers to understand is the Fair Labor Standards Act, which actually sets a floor for working conditions under certain characteristics, usually wages, hours, overtime, those minimum wage, those things that we're used to, applies across the country to create a floor for employers as well as cover and protect workers in different kinds of ways. So their jurisdiction extends to any employer, they call it enterprise coverage, that has annual dollar volume of sales or business at least 500,000. Or some specific businesses, which includes public sector and government agencies. And then you can also, even if you don't have 500,000 in revenue, be covered by the Fair Labor Standards Act if individuals in your employ engage in interstate commerce. And you can imagine that in this day and age, we all pretty much engage in interstate commerce. So their jurisdiction is pretty broad, and I don't believe it's any exaggeration to say that 90% of Michigan employers would be covered by the USDOL rule as it relates to misclassification. It's much likely higher than that, but that's what it does. So most states, including ours, have our own wage and hour divisions, and we have certain definitions that we include. So while this rule doesn't impact how we, as our wage and hour division, will analyze a situation, it does start to create a disparate impact and regulatory structure for employers across our state and can exacerbate challenges that we see. Today I wanted to give you an abbreviated view of the new rule. There's been a lot of press on this whole rule with the USDOL and misclassification, but the practical application is to consistently determine what an employee is when they have an investigation. I think it's important for everybody to understand that the USDOL nor us actually go out seeking to look for misclassification in and of itself. This is how they evaluate the employment status if a complaint is filed that's typically about wages and overtime, and whether or not that employment relationship actually exists to make sure that there is coverage. for any regulatory agency, the first thing we have to do is determine whether or not this is an employer or not. And we do that every time that we have a complaint. In 2021, the USDOL published a final rule changing the decades-long evaluation of employment status with what is known as the economic realities test, or you'll hear it called the totalities of the circumstances. They basically mean the same thing. What the new rule, I'll explain in just a minute, but what the 2021 rule did was changed the characteristics of what is in the economic realities test, as well as prohibited evaluating one of the 6 factors that are included in the economic realities test. As many of you know, California passed an evaluation process called the ABC test. This new rule is not the ABC test. We know that there is a lot of fanfare about California and that the way that they evaluate employment. This new rule is a reversion to using the decades-long economic realities test and totalities of the circumstances. So the final rule continues to affirm that a worker is not an independent contractor if they are, as a matter of economic reality, economically dependent on an employer for work. So consistent with judicial precedent, the Department of Labor, USDOL, as well as the way we evaluate this for MIOSHA and wage and hour, is to use these 6 factors. And what those are is the opportunity for profit of loss or loss depending on managerial skill, any investments by the worker or the potential employer, the degree of permanence of the work relationship, the nature and degree of control, and the extent to which the work performed is an integral part of the potential employer's business, as well as skill and initiative. And none of those weigh more than the others. So when you're evaluating this relationship, you look at all of those. That's hence the totalities of the circumstances. The 2021 rule adopted by the USDOL made it 5 factors. They weighted 2 as the dominant characteristics, which were control and opportunity for profit and loss, and they prohibited the department from evaluating whether the work performed is central or important to the potential employer's business. So it's important, again, to keep in mind that with either rule, nobody's investigating whether or not you're classified correctly until something happens with your employment that pulls in one of those other laws that we covered. And the same is somewhat true in Michigan, but we have actually different tests for different agencies. So it's a real challenge for us across all departments to make sure that we're evaluating the employment relationship the same way. So for example, MIOSHA and wage and hour evaluate employment based on this economic realities test. They use those 6 factors to determine whether or not you're employed. But under statute, our unemployment agency and workers' comp are required to use an antiquated IRS 20-point test, which actually creates divergent outcomes from amongst the departments and actually exposes employers to multiple investigations to determine whether or not someone is, in fact, an employee. Because the federal rule does not apply to our state enforcement or requirements for our statutes or all the departments, this is going to lead to not only state disparate investigations, but also now when you refer something, if you need to the feds, you're going to have another different investigation, almost all of those starting from scratch each and every time. So it's a return to decades of precedent. It's what the courts use to establish employee status. It's what we use in a few of our agencies and just kind of realigns what we do there. It does not mean that people that are independent contractors cannot be independent contractors. We have many of those that are legitimate businesses set up for themselves to do what it is they do. But we do have misclassification, and classification is important because most of our labor and employment laws apply to the employee-employee relationship. So when you are misclassified as an independent contractor, when you should be an employee, you lose workplace safety and health protections, you lose unemployment insurance benefits, you lose Social Security contributions, workers' comp coverage, paid or unpaid leave, wage and hour protections, including minimum wage, overtime, and how your wages are paid. You lose access to civil rights protections and discrimination, the Americans with Disability Act, and other access to training opportunities. And that doesn't even include the various tax obligations that an employer may skip out on because they're not classifying their employees properly. So when you start a business, that's good. We like that. If you are an independent contractor, this rule is not going to change your ability to be an independent contractor, be an employer for yourself, but it is going to make sure that as the departments are evaluating whether or not you have employees, this is what they're going to look at. So again, over the coming weeks, we'll be working with our USDOL counterparts to make sure we get the word out there, make sure other employers understand this. I think in Michigan. As I mentioned, we have different departments that look at this differently, so that does create some challenges for us that we'll want to talk about. But that was my goal today, is just kind of share with you that in about 11 days, 12 days, this will be the law of the land for the USDOL Wage and Hour Division. Mr. Chairman?
Mr. Harrison, do you have anything?
Well, Chair, committee members, I will say, as working 16 years in the wage and hour division, I've seen some of everything happen when it comes to misclassifying an employee. A janitor should not be an independent contractor. Someone working a cash register at your store should not be considered an independent contractor. So I do believe that this rule will help solidify a lot of the problems that I've seen over the course of my career. But as Director Egan stated, the different agencies determining if someone is a employee or not, different ways, it needs to be changed.
Thank you. Do we have any questions in relation to either Director Egan or Mr. Harrison? Representative Wozniak.
Thank you, Mr. Chair. Mr. Egan, historically, independent contractors, it's been difficult defining them. But what if you have a document, say the employer presents a document to the other person that says, I am an independent contractor? Is that sufficient proof, or do you have to go beyond that?
In any evaluation, you're going to do those 6 factors. So any documents between in that case, you would call it a contractor and a subcontractor, right, if they're a true independent contractor. But any document exchange between the two is just one of the pieces of the evaluation. So what we're going to look at is like what's actually happening. So just because I sign something that says I'm an independent contractor, if I'm going to the same place every day, the employer's telling me what to do, they discipline, they approve vacations, right? There may be circumstances that say this really is not an independent contractor relationship. If you are providing services, it's just going to be part of the evaluation, if that answers your question.
Even though that person might be adamant in saying, I am an independent contractor, there's still those 6 factors.
Correct.
Got it. Thank you.
Yep.
Representative Coons.
Thank you, Mr. Chairman. Can you help me understand, the new rule is being challenged in federal court. Is that going to be delayed? How's the implementation going to be applied until this is sorted out?
Yeah, potentially. So we have not yet seen a stay as far as I know. But, certainly a lot of federal rules get challenged. I would anticipate there's going to be some kind of stay. So if that happens, we'll kind of wait before we're out educating and doing our stuff. I would anticipate that the rule will go into effect at some point. I think it's primarily a reversion to what they did prior to 2021. So, I can't prognosticate about the courts, but I would anticipate there's going to potentially be a stay.
Got it. Before the March 12th?
But yeah,
It's hard to say. Again, that's an almost impossible question, but it is being challenged in federal court.
As far as I know, yes.
Got it. Thank you.
Yep.
Representative Wagella.
First off, thank you for coming here today. Sorry, my mic's being weird. So just like to kind of understand the rule with the 6 factors that are at play, is it just one of the 6 factors could rule a misclassification, or do you have to have elements of all 6?
None of them are weighted, so there's no one of those rules that says yes or no, and it's kind of hard to say, like, check the box, because it's not really that clear, but certainly things like the control. To Rep. Wozniak's question, if I say I'm an independent contractor, but I'm going to the same exact location every single day at the discretion of whoever's saying I'm an independent contractor, paying me an hourly wage, things like that, so you'll find those characteristics. But theoretically, no one of the 6 weighs more than the other, and you don't need all 6 to establish that relationship.
And then just a quick follow-up. So in terms of like number 3, degree of permanence of the work relationship, like I know some independent contractors, particularly like in like the therapy world, have to sign like year-long contracts and non-competes, but yet are still 1099s. Thoughts on that? I'm just kind of curious, would that be a misclassification of those workers?
Potentially. I mean, we always encourage folks that believe they're misclassified to file a complaint with our wage and hour division, because we can do that evaluation. There will be situations where something like that, based on those limited details, because we can't say on
Sure,
a blanket,
yeah.
but they may be employees, but it is possible that they could be independent contractors, right? So we really need to get those complaints in the door to make sure that we can evaluate whether or not somebody's employee is an employee or an independent contractor.
Thank you.
Representative Wozniak.
Thank you. Mr. Egan, is there an appellate process to these decisions?
Yeah, absolutely. Yeah, these are administrative decisions, so you have all of the administrative procedures within MORE and ALJs and all that kind of stuff. And then certainly, if you don't agree with that, you can continue to appeal to the courts.
Right.
Yeah.
Thank you.
Yep.
Thank you, Director Egan and Mr. Harrison. We appreciate you being here today.
Yeah, thank you, committee.
Now we're going to hear from Sally Dorak Fisher, a senior staff attorney from the National Employment Law Project. She will be joining us by Zoom.
Hi there, can you all hear me?
Yes.
Thank you so much for having me. I'm going to try to share my screen here and really just walk you through, without trying to repeat too much, a little bit more detail about what the 2024 independent contractor rule is designed to do and how it will or won't impact folks in your state. I did just want to add, while I'm thinking of it, I know there was a lot of, there's been some discussion about, the impacts on workers from misclassification and all the rights and benefits that get lost in that. But it's also important to keep in mind that misclassification is bad for state coffers to the extent that businesses that should be paying into your unemployment insurance trust fund and have workers' comp policies and things of that nature are sort of, not contributing their fair share. And it also hurts law-abiding businesses because it creates a real race to the bottom. Like, you can't compete on labor costs if somebody else is misclassifying and cutting 30% of their payroll that way. So I just want to quickly respond to those two quick points. All right, so can you all see my screen here? Okay, great. All right, so first, I just wanted to briefly, you all know who is an independent contractor versus who is an employee. So what the rule, like all analysis of independent contractor versus employees, is trying to get at is, what is an independent contractor? Who are they? And basically, in a nutshell, an independent contractor is someone who's running their own business, right? They have power to negotiate their prices or to set their prices. They make investments in their businesses. They market, they earn profits, they suffer losses. They're basically independent. Now, the Fair Labor Standards Act, of course, was passed after the Great Depression. We saw massive market failures, and Congress passed the Fair Labor Standards Act to combat conditions that were detrimental to the maintenance of a minimum standard of health and safety. And so basically that's our national minimum wage and overtime law. And it's designed to be the national floor, not that states can't go above it, but just that we have a national policy that no one will be paid less than a minimum wage if they're an employee. Now, it's important to keep in mind that the Fair Labor Standards Act defines employee incredibly broadly. They drew from state child labor laws at the time, and the definition of employee is to suffer or permit to work. So in other words, if you have reason to know that illegal work is going on in your business, you are suffering or permitting that work. It's intentionally broader than the common law. The common law basically focuses on, what do you have the right to control the manner and the means of the work? Like, so are you controlling your agents within your business? That's a more narrow common law definition. The definition under the Fair Labor Standards Act is intentionally broader than the common law. And so, courts have recognized, like, the Fair Labor Standards Act was designed to to defeat rather than implement contractual relationships. And it's designed to upset the freedom of contract. because we realize that individual workers don't have the power always to negotiate their terms and conditions. So the main question that the rule seeks to answer is, who can be fairly said to be running their own business such that we can say they're outside the scope of the Fair Labor Standards Act? Essentially, they're independent enough that they don't need these protections of these minimum protections of the Fair Labor Standards Act. And the way courts have phrased that is this person in business for themselves, or are they dependent on working in the business of another? Now, as you may know, the Fair Labor Standards Act didn't define an independent contractor. It only defined employee and employee. So what has developed throughout the course of decades is this economic realities test that you just heard about. It's not stated in the statute itself. It's something that's been developed through the courts. And as you just heard, the new independent contractor rule basically adopts the analysis that's been used by the courts for decades and decades. And so that's one of the take-home points of this, really, is that this rule doesn't really change the ball game in terms of who has been an independent contractor under the Fair Labor Standards Act for the past decades, because it's the same factors that courts have been using for many, many years. So here are the 6 factors, as you already heard about. Like, do you have opportunities for profit or loss that are based on managerial skill? And what that means is, this is not just, can you work extra hours to make more money? This is about, can you negotiate your wages, set your prices, and use some sort of managerial type skill to have profits, or, the worst case scenario, suffer losses. Do you make investments in your business? Is the relationship sort of ongoing, or is it, often independent contractors, they're project-based, right? So like, you have the plumber coming into your office to perform a job. That job is a discrete job. They come, they do their work, and they leave, and they set their prices. The nature and degree of control over the work is sort of an overlap with the common law, but it's more expansive than that. So for instance, does the employer have the right to surveil you while you're doing your work? Does it, do they tell you what your routes are going to be if you're a driver? Do they tell you where you have to be and when? Those kind of things are indicative of someone who's not running their own independent business, right? Then you have the skill and initiative required, and the degree to which the work is integral to the hiring business. So if you think about it, generally we have businesses and we have employees that are like, carrying out the main function of that business. So when you think of, I don't know, a grocery store, are the people that check you out in the grocery store, they're performing work that is integral to the function of a grocery store, stocking the shelves, things like that. So the workers who are doing jobs that the business really can't do without are integral to that business. So again, you take all these 6 factors and you look at the entire circumstances, and always guided by that North Star question, which is this person running their own business? Are they in business for themselves, or are they dependent economically on working in the business? So that's the economic realities test. It is a 6-factor test. It is well known. It's been around for decades. As was mentioned, there was this analysis is designed to replace an earlier analysis that the prior administration put into effect in January of 2021, in the waning days of that administration. And that rule was significantly narrower. It was actually, it elevated 2 core factors, which had no support from any sort of court case or any appellate case across the country. So it elevated two core factors, and then it narrowed those factors, looking to whether the worker had control and looking to whether control was actually actually enforced rather than, so for instance, contracts can be very powerful evidence of control, as the member just asked about. Contracts can be evidence of control or lack of control, but you have to look at both, because sometimes contracts can be evidence of how much power a hiring entity does. Like, and to answer your question specifically, before I came to NELP, I did represent low-wage workers, and we would occasionally see people forced to sign a contract saying you're an independent contractor, but then in reality, they were told when and where to show up, how many dollars an hour they were getting, all the terms and conditions of their work. So that the contract, you can't just take either the contract or, you have to look at both the contract and what's happening in practice. So that prior rule sort of said, we're not really gonna look at what the contracts say, we're gonna look at the course of conduct. And then it elevated opportunity for profit and loss and focused on things like, can the worker set their own schedule? Well, setting your own schedule is great, and flexibility is great, and it can be evidence of independent contractor status. But as courts have recognized, giving your employees a flexible schedule is a business decision. It's not necessarily the be all and end all. It doesn't necessarily reflect true independence. Like, if a business decides, as many businesses do, we're going to do an app, you can sign up and work your shifts. That's certainly a factor, but it's not anything to be elevated. So, this 2024 rule is sort of more in the vein of a course correction. It's not a major sea change. And I think, as the USDOL explained in the 2024 rule, it came to the conclusion that the 2021 rule that was in effect for a couple of years really didn't do service to the purpose of the Fair Labor Standards Act, which is intentionally broader than the common law, and narrowed it in some ways, and ways that were not supported by the case law and impermissible. So that's sort of where we're at and how this all came about. The rule, you are correct, the rule is being challenged. I believe there are 3 lawsuits now challenging the rule, and there's a request to stay the rule, but otherwise it will go into effect March 11th. I did just want to take a minute to touch on the ABC test, which is another rule. The ABC test has gotten a lot of attention because of California, but people should keep in mind that the ABC test is not new either. It was originally developed in the unemployment insurance context. It's been in effect, at one point, every state in the country used the ABC test for unemployment insurance. It's now in effect in over 21 states or 25 states. It's in effect in roughly half the states. And it's a clear, easy to apply rule with an important provision that presumes people are employees. And the reason why that's important is, it's a public policy issue. This is what legislators decide. Like, what do we want to err on the side of assuming that most people are not running their own independent businesses or not? And so the ABC test is sort of creates a presumption of employee status. That presumption can be overcome by a business if the business can show the worker meets all 3 things. And certainly in that regard, a contract would be important evidence of independence, but you'd also still look to what the workers actually do. And so I really just wanted to point out here that the ABC test is not something wildly left wing or anything. 21 states have it in their unemployment insurance laws, and several states use it for their wage and hour laws. You'll see there Vermont, Washington State, Massachusetts, New Jersey, and California, although they've gotten the most sort of press about it recently. Connecticut and other states have them for particular industries, like the construction industry has been rife with independent contractor misclassification. So the District of Columbia, their Attorney General did a report on the scope of independent contractor misclassification and the extent to which they were having law-abiding businesses that couldn't compete, and it was hurting coffers. Maryland, same thing. Landscaping as well was an industry they chose to cover. And then New York has a construction-related ABC test as well. So some states have decided to do it industry-specific. Other states have said, rather than having this myriad of different laws, we're just going to take the simplest test, presume employment, and you can overcome that presumption, and it's a more clear and simple test than the totality of the circumstances test. So, that's all I had for today. I hope I didn't repeat too much of what you already heard, and happy to answer any questions, or you can get back to your work. Thank you.
Thank you, Ms. Dworak Fisher. Are there questions? Representative Wagalla.
Thank you for your testimony. I was just curious if you could talk a little bit about how states, because I know like the rules we're talking about apply to federal law. States and local governments have their own, independent law from that. And if you could talk just a little bit more about the benefits of states putting in kind of their own rules / laws surrounding independent contractors.
Sure. Well, as I mentioned, the Fair Labor Standards Act is a national law. So that's necessarily going to be the floor. And Congress invites states to go higher, to do more, to do what's best for their communities, right? So I think that, a lot of states have seen a rise in independent contractor misclassification, particularly states that are concerned with their unemployment insurance trust funds, businesses not providing ample workers' comp policies, because if you classify someone as an independent contractor, they just don't show up on your payroll. So, there are certain red flags, I think, that state administrators or policymakers have noticed. Like, you have a business that's an LLC and they have no employees, but they have like 200 independent contractors doing the main part of the business. Like, the state is losing out on funding for, essential or critical safety net benefits. And then, we've heard from sort of businesses that are trying to play by the rules, like, hey, I can't compete against these guys that are going out and hiring people for 30% less because they just have them sign some form saying they're an independent contractor. And then those people, they might not even understand the consequences of it, but then when they don't get paid, they might file a complaint or go to a lawyer, and then the first fight you have to have is whether or not they're an employee or an independent contractor. So a baseline sort of an ABC test with a presumption is like the simplest and clearest standard to have. And I think as a public policy matter, this is obviously for policymakers to decide, but as a public policy matter, if our understanding is that most people who work for a living are not running their own independent businesses, then it's somewhat clear, simple, and efficient to have this presumption that you're not running your own business. But you can overcome that presumption if you have an independently established business, if you've filed with the Department of Assessments and Taxation, you're a business in good standing. Like, there are ways to overcome that presumption. So it's not, no, it's not killing legitimate independent businesses to have an ABC test. I mean, certainly all these states, you have 20-something states with unemployment insurance ABC tests. All those states have independent contractors. And this ABC test has been around since the 1930s, I want to say, 1935, I think maybe. And so it's not as if the ABC test has killed independent contracting, and nor should we want to, right? I mean, nobody's anti-independent contractors. We all love small businesses. We just want to make sure we're not supporting the businesses that are exploiting their workers and cheating the system.
Are there other questions of Ms. Dworak Fisher? I have one, Ms. Dworak Fisher. I want to reiterate that this newly promulgated rule, as you put it, doesn't create a whole new ballgame. It, in fact, is a reiteration of the long-established judicial precedent, I guess dating back to the Rutherford case from 1947 you posted. Is that all correct?
That's absolutely correct, yes.
Thank you for your testimony this morning. We appreciate it.
Thank you for having me.
You're welcome. So last spring we heard, last April specifically, we heard testimony on a package of bills that aim to rein in wage theft, and worker classification was one bill in the package, and hopefully this will be helpful to us as we take that under advisement and move forward. The final items on the agenda are House Bills 5164 and 5165, sponsored by Representative O'Neill. Representative Kolazar moves to report House Bill 5164 with recommendation. Before we take the roll, I do have cards on both 5164 and 5165, one from Ryan Seabolt of Michigan AFL-CIO. He supports the bill, doesn't wish to speak. And one from David Worthams from the Michigan Manufacturers Association. He opposes the bill or bills and doesn't wish to speak. And we have one from Stephanie Johnson from UWUA. She supports the bills and doesn't wish to speak. With that, Mr. Clerk, will you take the roll?
On the motion to report, Chair Hadsma,
Yes.
Representatives Menser,
Yes.
Kolazar,
Yes.
O'Neill,
Yes.
Andrews,
Yes.
Churches,
Yes.
Wagella,
Yes.
Wozniak,
No.
Mueller,
No.
Coons.
No.
Mr. Chair, you have 7 yeas, 3 nays, 0. Pass HB 5164 is reported as recommendation.
Thank you. Representative Churches moves to report House Bill 5165 with recommendation. Will the clerk please take the roll?
On the motion to report, Chair Hadsma.
Yes.
Representatives Menser,
Yes.
Kolazar,
Yes.
O'Neill,
Yes.
Andrews,
Yes.
Churches,
Yes.
Wagella,
Yes.
Wozniak,
No.
Mueller,
No.
Coons.
No.
Mr. Chair, you have 7 yeas, 3 nays, 0. Pass HB 5165 is reported as recommendation.
There be no further business before this committee. The House Committee on Labor is adjourned.